Welcome to the YouTube channel of Legally Trust. This video is one of the series of educational videos that will be available on this channel under the category General Awareness.
Hello friends, in today's video we will understand the differences between judgment, decree and order. Let us first understand what a judgment is. Under section 2 subsection 9 of the Code of Civil Procedure 1908, a judgment means the statement given by the judge on the grounds of a decree or an order. Judgment refers to the reasoning given by the court in order to support the decision. This means that the court addresses the issues raised in the suit and answers them with reasons. Issues are basically facts which are disputed by the parties to a case. A judgment is said to be the final decision of the court on the said matter in the form of suit towards parties. Order 20 Rule 4 subsection 2 gives the elements of a judgment, and it states that a judgment shall contain a brief facts of the case, point for determination, which means what material facts of the case the judge considered to arrive at the decision thereon, and all the reasons for making such decisions. A judgment is not appealable. As held by the Supreme Court of India, a judge cannot merely say suit decreed or suit dismissed. The whole process of reasoning has to be set out for deciding the case one way or the other. Now let us understand what a decree is. A decree is defined in section 2 subsection 2 of the Code of Civil Procedure 1908. It is the official proclamation of the adjudication of the case by the judge. It is passed in a suit initiated by the presentation of a plaint. It deals with substantive legal rights of the parties. It clearly ascertains the rights of the parties concerned. The court, while passing the decree, gives a description about the rights of the parties. There can only be one decree in a suit. It is a conclusive determination of the rights of the parties, and there must be a formal expression of adjudication, that is, the court must formally express its decision in the manner which is laid down by the law. It is appealable in all the cases except in cases which are barred by the law. There are different types of decrees which include preliminary decree, final decree, partly preliminary decree, or partly final decree. A decree is stated as a preliminary decree when the rights of the parties regarding all or any of the matter in dispute are determined in the adjudication, but it does not dispose of the suit completely. The preliminary decree is only a prior stage. The final decree is a decree which disposes of a suit completely and settles all the matters in dispute between the parties. The final decree does not leave any matter to be decided further. The key differences between a judgment and a decree are: judgment is a statement given by the judge on the grounds of a decree or an order. It is not necessary for the judge to give a statement in a decree, though it is necessary in a judgment. It is not necessary that there should be a formal expression of the order in the judgment, though it is desirable to do so. Order 6 Rule 20 states that the last paragraph of the judgment should state precisely the relief granted. A judgment contemplates a stage prior to the passing of a decree or an order, and after the pronouncement of the judgment, a decree shall follow. Now let us understand what an order is. Order is defined in section 2 subsection 14 of the Code of Civil Procedure 1908 as the formal expression of any decision of a civil court which is not a decree. It is passed to regulate the court proceedings. There can be more than one order in a suit. The adjudication of the court which is not a decree is an order. Hence, an order may or may not determine the rights of the parties. Order is an official announcement of the decision taken by the court defining the relationship of the parties in the proceedings. It can be passed in a suit initiated by the presentation of a plaint, application, or a petition. It deals with the procedural legal rights of the parties. An order is always final and may be appealable or non-appealable. The key differences between a decree and an order are: the formal proclamation of the adjudication by the court of law explaining the rights of the parties concerned, judgment. The suit is called a decree, while the legal announcement of the judgment taken by the court defining the relationship of the parties in the proceedings is called an order. A decree is given in a suit initiated by the presentation of a plaint. On the contrary, an order is given in a suit initiated by the presentation of a plaint, application, or a petition. A decree is concerned with the substantial legal rights of the concerned parties, whereas the order takes into account the procedural rights of the parties concerned. In a decree, the rights of the plaintiff and defendant are clearly ascertained. As against this, in case of an order, it may or may not clearly ascertain the rights of the plaintiff and the defendant. There can be many orders in a suit while there is only one decree. A decree may be preliminary, final, partly preliminary, or partly final, whereas an order is always final. A decree is usually appealable except when it is barred by the law. Conversely, an order is appealable or non-appealable. Judgment, decree as well as orders are governed by the Code of Civil Procedure of 1908. Hope this information was useful to you. Thank you for watching.
Hope the information contained in this video was useful to you. We look forward to each one of your support and cooperation in making this initiative a success. For more details about the trust, do visit us at www.legalaidtrust.in. Kindly subscribe this channel and click on the bell icon to get the latest updates about various law-related educational videos. Thank you for watching us and have a good day.